Test 1, 2, 3, test. Yeah, it's fine. Test 1, 2, 3, test. Test 1, 2, 3, test. Hello, everyone, and welcome to this week's Let's Talk Jackson, which is a special edition because I'm telling you, I was not expecting to do a Let's Talk Jackson specifically about the property tax assessment chaos that's going on right now. Initially, I was going to go into our current budget crisis that's going on in Jackson County. However, because of the Jackson County Circuit Court decision that was issued on April 1st, 2025, that led to such great confusion in our community, I felt very compelled to have a Let's Talk Jackson specifically about this ruling and what it actually means, which, if you've been following my pages, it's long story short, it's basically states that the state tax commission's order is a valid order, but the courts also ruled prior that the state tax commission cannot use the courts in order to enforce its August 6, 2024 order. And we're going to get into that. But I first want to give a disclaimer here that my name is Stacy Lake. I am a civil litigator. I specialize in personal injury, commercial litigation. I'm basically a lot of law that is under the realm of civil litigation, but I do not specialize in lawsuits against municipalities. So please take everything that I say as speculation, conjectures, and everything that I say here are allegations. I am going to today go over the Jackson County orders on the property tax assessments and what that means for you as a Jackson County taxpayer. And this is not a legal opinion. This is only my opinion as to what these orders say. And what it will have on a Jackson County citizens. What a Jackson County property owner who's actually looking for a refund or looking for their taxes to be recalled, what it actually means for them. But first, I want to say hi to Lisa and hi to Tracy. Thank you for tuning in. We are going to get into all of your guys' questions and comments because this Let's Talk Jackson isn't going to be as long as the typical Let's Talk Jacksons, but we are going to learn a lot today, specifically about res judicata and about what is exactly going on with the property tax assessments. So here today, and hold on a second, let me just check something really quickly. Oh, yes. Okay, I'm sorry. I'm reading Tracy's comment, but the streams are working fine. So we are going to first look at this overview that I created about the three cases, because this is where confusion derives from. Multiple local newspaper sources had headers basically stating that the judge ordered the recall of the 2023 property tax assessments, but those headers were completely wrong, and we're going to get into it now. What you need to know is that when it comes to the state tax commissioner or state tax commission filing a lawsuit against the Jackson County government, there are three important cases we have to look at. And these are three separate cases. So case one, which is case number 2316 CV 33643, is the one that we had the jury trial over last summer, and where the case was dismissed with prejudice due to, in my opinion, Andrew Bailey refusing to take a deposition, okay? So when I'm talking about case one, I'm talking about the case that was dismissed with prejudice that had several days of jury trial, but ultimately was dismissed by the State Tax Commission. We then have case number two, which is the case that a lot of people did not know about, which is case number 2416-CV25759, which was another case that was filed by the State Tax Commission against the Jackson County government. Basically, the State Tax Commission was using this case to force the Jackson County government to comply with its August 6, 2024 order that they released that basically stated that the property tax assessment was flawed and that they needed to roll the property taxes back, okay? So that one is case number two. Case number three is case number 2416-CV25478. And this was a case that was filed by the Jackson County government against the State Tax Commission, that where the Jackson County government was basically asking the judge to rule that the State Tax Commissioner's August 6, 2024 order was an invalid order. And the reason why I separated these cases out is because on April 1st, 2024, the judge came back on this specific case and ruled against the Jackson County government and made a finding that the State Tax Commissioner's August 6, 2024 order was valid. However, that same judge in case number two ruled that the State Tax Commissioner's order would be unenforceable due to res judicata. And I'm sorry, 2025. Thank you so much, Lisa. So this is the April 1st, 2025 order. But the November order for case number two, which basically states that the State Tax Commission cannot use the judges to enforce this order, would still apply to case number three. So let's go into the history of case one, case two, case three. So case one, as I stated before, it was the State Tax Commission filing against the Jackson County government. It was filed on December 19th, 2023, and this is the case that specifically went to jury trial, and the State Tax Commission dismissed this case with prejudice, which if you've been following my prior podcasts or my prior Let's Talk Jacksons, I put together a long timeline basically showcasing that, in my opinion, the reason why the case was dismissed with prejudice was due to the fact that Andrew Bailey, our current Attorney General, did not want to have a deposition due to his ex parte communications with Jackson County legislator Sean Smith. And Lisa, I know this is very confusing, and if you have any questions, just let me know, because I'm here to break it down for you. So if you have any questions, just let me know. But I'm going to do my best to make this as simple as possible. But just let me know. So that's case number one, which, if you remember, it went to jury trial for 3 days, and the last day was jury trial day number 4, and it was dismissed by the State Tax Commission, and the judge ordered that the case be dismissed with prejudice. Then we go to case number 2, and this was another case filed by the State Tax Commission against Jackson County government, and this was filed on September 9th, 2024, and this case was the State Tax Commissioner stating that the Jackson County government needed to follow its August 6, 2024 order. Now, going back, if you remember, when the State Tax Commission filed its motion to dismiss, one of the reasons why it stated that was because the State Tax Commission on August 6, 2024 issued an order that basically stated that the Jackson County property tax assessments were invalid and therefore ordered the Jackson County government to essentially roll our property taxes back to a 15% cap. And that, again, was done on August 6, 2024. Case number 2 was filed because the Jackson County government refused to follow the state tax commission's order, and thus the state tax commission went to the courts asking the courts to force the Jackson County government to follow that order, essentially recalling the property tax assessments in 2023, so that if any property was assessed at a value over 15%, it would be capped at a 15%, at a value that does not exceed 15%. Now, in case number 2, this case was dismissed also with prejudice due to a legal theory called res judicata. Okay, and we are going to really get into what res judicata is, but basically what the judge essentially ruled in case number 2 is that the state tax commission cannot use the courts to enforce the state tax commission's August 6, 2024 order because they had the ability to get that relief that they sought, which means recalling the 2023 property tax assessments in case 1. But since the state tax commission dismissed that case and the case was dismissed with prejudice, they cannot relitigate the same case twice and ask the court again to enforce a similar type of relief, which they deemed that this order was the same type or a similar type of relief that they were asking in case number 1. And so they ruled, and this ruling happened on November 20th, 2024, they ruled that the state tax commission's order is unenforceable by the courts, meaning that the courts cannot compel the Jackson County government to follow the state tax commissioner's order. Now, case number 3 is a case that was filed by the Jackson County government against the state tax commission, basically asking the court to find the August 6, 2024 order invalid. And I talked to a lot of attorneys about this, and honestly, I agree with a lot of my colleagues where I don't think that case number 3, after the Jackson County government got the order from the court about case number 2, they should have dismissed case number 3. So case number 3 basically is the Jackson County government asking the court to declare the state tax commissioner's August 6, 2024 order invalid, okay? But what happened on April 1st, 2025 is that the court, and in this case, case number 3 went to trial, okay? Oh, and also case number 1, I made it error. I said went to jury trial. It was a bench trial, so excuse that. But case number 3 went to trial, okay? And for several days. And the courts made a finding that the state tax commission's August 6, 2024 order was in fact valid, that there was significant facts to show that the 2023 property tax assessment was or violated our Missouri statutes, and ruled that the state tax commission's August 6, 2024 order was a valid, legally binding order. However, if we look at case number 2, and this is where the confusion comes, and just to say again, case number 2 and 3, they both had the same judge. So the same judge wrote both of these orders, okay? Even though in case number 3, The judge ruled with the state tax commission and stated that their August 6, 2024 order was valid. There's no relief actually given to the Jackson County property owners because in case number 2, the same judge ordered that the state tax commission cannot use the courts to enforce the state tax commission's order. Okay? And we're going to break this down further. So, in simple terms, we have a valid state tax commission's order, but it's unenforceable. The courts cannot enforce it due to res judicata. Okay, so I'm going to take a question by Tracy. Tracy says, does the state tax commission rule over the county government? So the way that the state tax commission, the way that the pyramid of authority is stacked is basically at the top when it comes to the taxation matters in Missouri government. The top authority is the state tax commission. Okay, then goes the BOE. And then goes the county governments, okay? So basically the county governments, they assess your property taxes. You appeal to the Board of Equalization. That's a lower tier. The Board of Equalization determines whether or not the county government's determination of your property assessed value complied with law or not. So they make that determination at the BOE stage. And then if that gets appealed, it goes to the state tax commission, which the state tax commission can then overrule the Board of Equalization's authority. So the state tax commission oversees the taxation process in Missouri. However, when we come, generally speaking, if the state tax commission makes an order, the Jackson County government has to follow that order. However, if the Jackson County government refuses to follow that order, the way that the state tax commission uses, or the method that the state tax commission used in order for the Jackson County government to follow that order is through the courts, okay? But because of the issues stemming from res judicata, in this case, the courts have made a decision that the state tax commission cannot use the courts to enforce their order, okay? And we're going to get more into that. Lisa asks, so why can the county use the courts to attempt to invalidate the order? So the county did the same thing that the state tax commission did. So as the state tax commission filed a lawsuit against the Jackson County government for allegedly having an improper 2023 property tax assessment, the Jackson County government filed a lawsuit against the state tax commission, basically stating that their August 6, 2024 order was invalid. So anybody can raise any cause of action, right? But at the end of the day, with all causes of actions, it all goes to the courts, and the courts decide whether or not who complied with the law and who did not. And in case number 3, which I'm going to go back on, in case number 3, the court found that the state tax commissioner's order in August 6, 2026 was a valid order. So the Jackson County government lost that case. However, there was no relief given to the state tax commission because they didn't seek any relief, because the prior relief that they asked for in case number 2, essentially to roll back, have the court force the Jackson County government to comply with their August 6, 2024 order, was found to be unenforceable by the courts due to res judicata, which we're going to get into right now. So the question then becomes, what is res judicata? So res judicata means that the same case cannot be litigated twice once it's been judged on the merits. So basically, I'll give an example really quickly. So say, let's give this example. So say if I'm walking by a store, okay, there's oil on the ground. I slip, fall, break my knee on the oil, okay, and I sue the store for negligence, saying that they provided an unsafe environment for their customer because there was oil on the ground, okay. So say if I file that case, I have a trial on the case, but I dismiss the case during trial and get a dismissal with prejudice, okay? Meaning I cannot refile the case. I cannot then refile another case stating that this store caused, instead of negligence, it's gross negligence with the courts because of res judicata, because the courts will not allow the same case to be litigated twice if one case has a final decision, which a final decision is either a judgment, a final judgment given by a judge, or a dismissal with prejudice, okay? And so if a case has a final judgment issued by a judge or a dismissal with prejudice, that case cannot be refiled and brought back to the court under the theory of res judicata. So when we're talking about dismissal with prejudice, we have to look at the rule of 67.01. And this is the Missouri Supreme Court rule that specifically goes between the differences of dismissals without prejudice and dismissals with prejudice. And yes, Lisa, it is the same as double jeopardy, except double jeopardy more so applies to crimes, so like to criminal law side, and res judicata is the civil side. But yes, the same theory applies, that double jeopardy, res judicata is basically similar in the fact that you cannot relitigate the same case twice. So Rule 67.01 basically states a dismissal without prejudice permits the party to bring a dismissal without prejudice permits the party to bring another civil action for the same cause, unless the civil action is otherwise barred. A dismissal with prejudice bars the assertion of the same cause of action or claim against the same party. So in our legal system, cases are dismissed without prejudice quite often. And usually when a case is dismissed without prejudice, the filer has 1 year from the date of dismissal without prejudice to refile their case. Res judicata does not apply to those cases. Res judicata specifically applies to cases that were dismissed with prejudice, which in this case, when we look at the analysis in case number 2, we're going to see the judge is very much focused on this, because I'm transitioning right here. This is the order that was given on case number 1. This is the case that went to the trial in the summer as to whether or not the 2023 property tax assessments were lawful. In case number 1, we see that the judge ordered that the action is dismissed with prejudice as of the refiling thereof, meaning that this cause of action was dismissed with prejudice, meaning that it cannot be refiled, okay? So, basically, in layman's terms, res judicata bars relitigation of the same case twice when the matter has been decided upon by the courts. Now, as to the question of the standards that the court has to find to see whether or not res judicata applies. It's a 4-element standard. So they have to find all 4 elements to be true in this matter. So the first element is they have to find that the identity of the thing sued for is similar to the case that was dismissed with prejudice, okay? The second is the identity of the cause of action. Third is the identity of the parties to the action. And 4, the identity of the quality of the person for or against the claim has been made. So if the court finds that all 4 of these elements are true, then they will dismiss with prejudice a case due to res judicata. Now, when we go back to case number 1, this is basically just a recap before we really get into this. Case number 1 was the case that went to bench trial in the summer. It was filed on December 19th, 2023, and the State Tax Commission then voluntarily, so the State Tax Commission on their own behalf filed a motion to dismiss this case, which the judge then dismissed the case with prejudice on trial day 4. And this essentially meant that the cause of action and the relief that was being asked for in case number 1 cannot be relitigated by the courts due to res judicata and Rule 67.01, which governs the motion, which governs cases that are dismissed with prejudice. Now, going into how Missouri courts apply res judicata to cases that were dismissed with prejudice, Missouri has a very long history of holding that res judicata applies to cases that were dismissed with prejudice. And this is even so that so when a case is dismissed with prejudice, the judge makes no findings as to the facts that were litigated in that case, okay? And no decisions are reached in a case that's dismissed with prejudice. But historically, the Missouri courts have argued that since the case is prevented from being brought in front of the court again, res judicata will apply. So now we are going to go into case number 2. So this is again the recap of what, like an overview of what happened in case number 2, which was a case filed by the State Tax Commission against the Jackson County government. It was filed on September 9th, 2024, and dismissed with prejudice on November 20th, 2024, due to res judicata. And in this case, the judge ordered that the State Tax Commission cannot use the courts to enforce the State Tax Commission's August 6, 2024 order. Now, I'm going to do something differently than I usually do in my other Let's Talk Jacksons. Usually, I have the court's, I take notes of what the court's decision was, and I put that into my PowerPoint presentation, and we just go through the PowerPoint presentation. But due to what a lot of people have been saying about this case, I decided that I'm going to go through my notes with the court order present right here, so you could actually read for yourself what the judge is saying and make your own decision, okay? So this is the case where the State Tax Commission's this is the case that the State Tax Commission filed against the Jackson County government, where the judge dismissed the case with prejudice, basically making the finding that the State Tax Commission cannot use the courts to enforce the order. Now, as you see on this first page, it says order denying defendant's motion to dismiss and court's order and judgment sua sponte dismissing case based upon Rule 67.01. Okay? As we shown before, or as I stated before, Rule 67.01 specifically is referring to the Supreme Court rule that governs dismissals with prejudice, okay, and how you cannot refile a case that's been dismissed with prejudice. Now, on the first part, and we're going to get into it, where it says the order denying the defendant's motion to dismiss, what happened was the Jackson County government, who are the defendants in this action, they first filed a motion to dismiss when they should have filed another motion called a summary judgment motion, and we'll get into that, to basically say that they cannot, or the state tax commission cannot litigate this case due to res judicata. But they filed it as a motion to dismiss, and the court noted that filing of the motion to dismiss was improper. However, the court then made an order sua sponte. So sua sponte essentially means to the court's own accord or voluntarily. So the court basically, after they had this evidentiary hearing going over all of the facts with regards to the res judicata issue, the judge made its own order that determined that that this case 2 is actually barred, and the state tax commission's August 6, 2024 order is unenforceable. So let's get into it. And if you have any questions, please let me know. But I'm going to try to make this as simple as possible. But I understand this is very deep in the weeds with legal theory. But I'm trying to explain what happened here, and so that you guys can go out to your community and explain the current status of the property tax assessments lawsuits. So on the first page, we see that it says the plaintiffs appear by attorneys, deputy attorney general, so the plaintiff, which is the state tax commission here, is appearing, and the defendants, which is Frank White, Gail McCain Beatty, the Jackson County Board of Equalization, and Mary Jo Spinell, who's the clerk of the Jackson County Legislature, are also appearing by the county counselor's office. So let's get into this order. So this page essentially states that on September 9th, 2024, the State Tax Commission filed a petition against the Jackson County government asking this court to force the Jackson County government to comply with the State Tax Commission's order that was issued upon them on August 6, 2024. The court made this finding that this action, which is case number 2, stemmed from case number 1, which was the 2023 reassessment of Jackson County real property. The judge then goes into the history of the first lawsuit in this procedural background. So we're over here right now. And basically states that the first lawsuit was filed by the State Tax Commission to recall the 2023 property tax assessment. She makes note of the parties to the case and the cause of action and the relief that was requested by the parties. In this, she notes that in case number 1, the parties to the action in case number 1 was the State Tax Commission and the Attorney General Andrew Bailey, and the defendants in case number 1 was Jackson County Executive Frank White, County Assessor Gail McCain Beatty, Jackson County Board of Equalization, the Jackson County Legislature, and Tyler Technologies, okay, which is going to be important because when we look at this case here, we have similar, almost identical parties. We have the State Tax Commission, which was also a party in case number 1, and we have Frank White, Gail McCain Beatty, the Board of Equalization, and the clerk of the Jackson County Legislature, which were defendants in case number 1. Okay, so the judge is now making parallels to both of these cases. So now we're going to this section. The judge specifically looks into the cause of action that was filed in case number 1, okay? The judge states that the Jackson County 2023 property tax assessment in this case, or the State Tax Commission basically stated that the Jackson County's 2023 property tax assessment failed to comply with the law, and that these failures stemmed from the Missouri statutes 137.115, 137.180, 137.275, 138.030, and 130.060, okay, and goes into a summarization as to what those statutes are, what the State Tax Commission was stating in the original case about those statutes, and how the Jackson County government violated those statutes in their 2023 property tax assessment. The judge stated that in case number 1, the State Tax Commission alleged that the Jackson County's 2023 property tax assessment failed to comply with the law, that the failure stemmed from these statutes, and these statutes specifically went into the failure to provide proper notice of physical inspection, the failure to perform required physical inspection, the denial of access to administrative remedies, the dysfunction of the administrative review process, and other negligence claims that stemmed from these statutory violations. And the judge also here, if you look here, makes a note about the MMPA claim that was also dismissed with prejudice. So, top here, the judge then goes into the history of the actual. Actually, before I get into that, the judge also said something else here too that's important. So the judge talks about the relief that the Jackson County government attempts to ask for, and which is stated right here. So the relief that the State Tax Commission asked for was, first, an order declaring any increase in the 2023 assessed valuation of implicated properties would be held void. 2, preventing, which is the injunction part of this, the Jackson County government from collecting or levying any real property tax based upon the increased value of the 2023 assessments. 3, limiting the increase of the assessed values to 15%. 4, an order declaring the county's duties. 5, a refund of any overpayment. And 6, an order compelling the county to execute these duties with respect to the assessments of the real property. So in this part, the judge is going over the history of the trial in case number 1, okay? So the judge remarks that the trial court had trial on June 27th, June 28th, and July 8th, and a fourth date of trial that was supposed to occur on August 9th, 2024, but it didn't occur. The judge further remarks that on August 6th, the State Tax Commission entered an order mandating that the Jackson County government correct the 2023 assessment roll to reflect the increases that did not exceed 15%. So this is rolling back the properties to the 15% cap. 2, the properties that were still in appeal to receive valuations that did not exceed over 15%. 3, that the Jackson County government would have to comply with the order within 30 days of the date of this order. 4, that the 2024 valuations would reflect the correct 2023 valuations. And 5, to take all necessary actions to ensure future compliance with the state laws regarding the assessments. So then the court then makes a note here that the trial court on August 8th, 2024, entered its order granting the motion for leave to voluntarily dismiss the case with prejudice, okay? So, on August 7th, 2024, we have to remember that the State Tax Commission provided the order. So let me go back. August 6th, 2024, the State Tax Commission makes an order ordering the Jackson County government to essentially roll back the 2023 property tax assessed values to give a 15% cap on any property valuation that received a valuation of over 15%. On August 7th, 2024, the State Tax Commission provided notice to the Jackson County government of its order and told them to respond to the order no later than September 4th, 2024. On September 4th, 2024, the Jackson County government responded by filing a petition for judicial review, and this is the third case, okay? So after the State Tax Commission gave their order to the Jackson County government and told them that they had to comply with this order, the Jackson County government responded by filing their own lawsuit against the State Tax Commission, which is case number 3. And that was the case that was decided upon on April 1st, 2025. And I'm going to show you quickly what I mean by that. So, actually, according to this filing, it was decided on March 31st, 2025, but it was reported on April 1st, 2025. But this is the judgment of case number 3, okay? But we're back to case number 2. So we go to the respondent's motion to dismiss. So in this section, the judge is basically talking about the Jackson County government's motion to dismiss and what the judge's opinions on it are. So the Jackson County government essentially argued that case number 2 involving the State Tax Commissioner's order was the same exact cause of action that was issued in the first case, except that the State Tax Commission was doing this through its order instead of using the courts. So essentially, the Jackson County government argued that the State Tax Commissioner's August 6, 2024 order was trying to get the same relief that was sought in case number 1, and how that should be barred because of the issues arising from res judicata when the State Tax Commission dismissed their case with prejudice and therefore cannot relitigate, and they cannot ask the court for the same type of relief. And so they're saying that due to this, they cannot ask the courts to issue the same type of relief that they could have received in case number 1 in case number 2. Okay? And if you have any questions, please let me know. I know this is confusing. Jackson County government then argues that the State Tax Commission is arguing the same cause of action and claim in case number 1 and therefore is barred due to res judicata. The State Tax Commission responds that that they agree that both cases involve similar questions of law and fact, but that the subject matter is different from case number 1 because case number 2 seeks to enforce a final agency decision, while case number 1 brought a legal action based upon Jackson County defendants failing to perform duties as it related to the 2023 property tax assessment. So, and I just wanted to make this clear to everyone. This is where I'm quoting right here. The State Tax Commission responds to the motion to dismiss, asserting that while both cases involve similar questions of law and fact, the subject matter differs in the way that I stated previously. Okay, so they agreed that this cause of action had similar facts and similar laws, but the key difference is that they were trying to get the relief through the order of the State Tax Commission's August 6, 2024 order instead of the relief through the courts in case number 1. And just to remind people, the Jackson County government argued that relief is barred because they could have asked for that same type of relief in case number 1. So then we go to the standard of review section. And so for people who are unfamiliar with what a standard of review is, the standard of review essentially is when is basically giving the roadmap or the guidelines or rules that the courts are going to follow in order to determine what their ultimate findings or ruling is going to be on this case. So when we look at this standard of review, and I'm going to go to the important section here. Pages 5 through 7, because in these pages, it's the judge explaining through case law, like what guidelines she's going to use. So pages 5 through 7 discuss how the motion was filed as a motion. She first discussed how the motion that was filed by the Jackson County government was a motion to dismiss, but it should have been filed as a summary judgment. So the difference between a motion to dismiss and a summary judgment is they essentially ask for the same type of relief, meaning that they want the courts to find that there's no case here due to some section of law, that the courts cannot make any findings on this case, and the case ultimately needs to be thrown out. Except a motion to dismiss, inside of motion to dismiss, the judge can only look at the filed pleadings, while in a summary judgment motion, the judge can look at exhibits and use those exhibits in order to make their decision. The judge basically states in pages 5 through 7 that since the Jackson County government and the State Tax Commission used exhibits to prove their point that res judicata either applies or does not apply to their cases, this case should have been filed as a summary judgment motion. And that's the overview of summary judgment. You don't need to know anything else besides that, but this is me explaining to you what the judge means by that. So then the judge explains that there was a hearing on November 13th, 2024. We're going to go to this hearing. There was a hearing on November 13th, 2024. And in this hearing, this is the bottom page 6. In this hearing, the judge brought up the issue that there was that this should have been filed as a summary judgment. But during this hearing, the state tax commission did not object for the court to consider the attached documents while issuing or making its final order. So, give me a second so I can show you specifically where it says that in here. So here it is. It's right here. So it says right here, the court held a hearing on November 13th, 2024, wherein the parties argued the motion to dismiss. Then we're going to skip that. The state tax commission did not object to the trial court's consideration of documents attached to the motion and in fact, meaning that the state tax commission, even though this motion to dismiss, according to the court, was improperly filed, the state tax commission said it was okay for the judge to make their determination of whether res judicata applies to this case or not, based upon the evidence that was presented in this November 13th, 2024 hearing. So now we're going to get into the actual motion to dismiss. So, and also the sua sponte, which the sua sponte is basically Latin for in the discretion of, or a voluntary act of the court, meaning that if when a judge issues a decision sua sponte, that means the judge is, like, besides everything that happened, the judge is making their own decision voluntarily without asking for the parties to file a motion to argue this, okay? And we're going to get into that. But in this respondent's motion to dismiss pursuant to Rule 67.01, the judge first makes a ruling on the Jackson County government's motion to dismiss by excluding all of the evidence that was presented besides the pleading that was filed. Okay, so she's only looking at the petition filed by the state tax commission. And when the judge excludes the evidence and only looks at the petition, the judge made a determination that the motion to dismiss must be denied because they had a cause of action just specifically looking at the petition. However, the judge then views this on their own volition. This is the sua sponte review. And so when the judge is reviewing it sua sponte, the judge essentially is looking at all of the evidence provided by both sides. So they're looking at the court order that was provided in case number 1 with the pleadings that were filed in case number 1. And the judge is making her determination as to whether or not this case is barred due to res judicata, aka whether or not the state tax commission is relitigating the same case twice. Now, in this, it says, I want to read a specific section in this order, because this is a lot. She cites a lot of good case law in here to give clarification as to why she's making the determination the way that she's making. But she basically states here, if a court is on notice that it has previously decided the issue presented, the court may dismiss the action sua sponte, which, again, sua sponte means on their own volition, okay? Even though the defense has not been raised. This result is fully consistent with the policies underlining res judicata. It is not based solely on the defendant's interests in avoiding the burdens of twice defending a lawsuit, but is also based on the avoidance of unnecessary judicial waste. So the judge is using this paragraph, in my opinion, to basically state that the reason why they're making this decision sui sponte is because they essentially do not want to have another hearing about the res judicata issue, especially since all the evidence was presented about the res judicata issue in this hearing. So now here, in this section, the court is arguing that since all the parties properly briefed and argued the issues pertaining to the res judicata situation, and that they argued these issues in the November 13th, 2024 hearing, the court has authority to make the decision sui sponte, which means on their own volition, on whether or not res judicata applies. So next, in this section, the judge is talking about why she made the decision to find that this case, that case number 2, that res judicata applies to case number 2. And this is essentially the case law that she's using. So the judge is basically citing case law that states that res judicata applies not only to cases that receive judgment, but also applied to cases that were dismissed with prejudice where the merits of the case were not reached. She then cites to the 4 elements of res judicata, which are right here. And basically, as a reminder, the four elements of res judicata is the identity of the thing sued for. Hold on a second. The identity of the thing sued for, the identity of the cause of action, the identity of the parties to the action, and the identity of the quality of the person for or against the claim is made, which are the 4 elements that the judge has to basically find that these 4 elements are true in order to apply res judicata and bar the state tax commission from receiving any relief for Jackson County not complying with its August 6, 2024 order. So in here, in this page, the judge makes specific notes, and these are notes that I think when we go over it, it clarifies a lot of issues with the res judicata. So first, the judge notes that res judicata applies not only to claims and issues that were in front of the court, but also to every claim properly belonging to the subject matter of the litigation in which the parties exercising reasonable diligence might have brought forward at the time. So what the judge is stating here is that res judicata doesn't just apply to the claims that were litigated in case number 1, but also applies to any other case that could have potentially been filed in case number 1. So let's give an example really quickly. So say we go back to the slip and fall. A person slips and falls in a business, breaks their knee and their ankle, but they only sue for the damages regarding their knee, right? Say they get a judgment back, basically saying that, yeah, the shop was negligent and should award you damages for the damages caused by your knee. That same person can't then file another cause of action asking for damages due to their foot, because the judge is going to argue that they should have litigated the damages done to their foot in the first case instead of waiting until the first case was resolved and, asking for it to be relitigated in the second case. The same type of situation applies here. Second, the judge makes a note that separate legal theories are not to be considered as separate claims, even if the several legal theories depend on different shading of the cause of action, or would emphasize different elements of the facts. So what she's basically stating here with this law is that the other side cannot use new legal theories to relitigate the same matters, that they should have provided these legal theories in the first case. Also, the judge basically states in her notes that for a subsequent claim, so for another claim on the same transaction to be considered separate, there must be new ultimate facts as opposed to evidentiary details that form a new claim of relief. So this essentially means that for a cause of action to be considered separate, which that's what the state tax commission has to prove, that this cause of action is different from the cause of action in case number one, that there has to be new facts that differentiates it from case number one, and that these facts have to be have to form a new claim of relief, so a different claim of relief than from case number one. The judge then notes that to constitute new ultimate facts, those facts that form the basis of the new claim for relief must be unknown to the plaintiff or yet to occur at the time of the first action. So, in this case, the state tax commission, the judge essentially is going to make her argument that the state tax commission's August 6, 2024 order essentially could have existed with the first case still proceeding, or that the state tax commission could have filed their August 6, 2024 order before they actually filed the lawsuit and still have been entitled to the same type of relief that they were asking for in case number one. But the fact that they filed the lawsuit first makes this whole issue of res judicata, because since the tax commission knew that they were going to issue the August 6, 2024 order, and that the order's facts were based upon matters that already occurred before the time that the first action was filed, the judge is going to make findings that the res judicata applies, and thus any relief sought by the state tax commission's August 6, 2024 order will be barred. So the judge then makes findings on, she goes through all the four elements of res judicata. So first, on the first element of res judicata, which is the identity of the thing sued for, the judge basically states that the allegations that were presented by the state tax commission and the relief sought presented by the state tax commission in case number two were nearly identical to the allegations in case number one, and therefore the first element for res judicata is met. So then the judge goes to the second element of res judicata, which is the identity of the cause of action. The judge makes the finding that the identity of the cause on the identity of the cause of action, that res judicata, like for res judicata purposes, it does not refer to the form of action in which the claim is asserted, but for the cause of action, which means the underlying facts combined with the law giving a party the right to remedy to one form or another. So essentially, the cause of action here that the judge is talking about is the judge is taking the facts that were alleged in case number one and case number two, and the application of the law that was applied in case number one and case number two, and basically asking, is this the same? Is the relief, is the law that they're using with the facts in case number two the same as case number one? And the judge finds that it was virtually identical here. The judge specifically states that the requested remedies against Jackson County respondents is set forth in case number one, and the order for which the state tax commission seeks to enforce are virtually identical. And so she found the second element in order to show res judicata. Now, then when we go to, she then continues with her analysis as to why the identity of the cause of action, or the second element, was met. And so the judge basically states that the first case and the second case both derive from the same cause of action regarding the 2023 property tax assessment and the application of various violations of Missouri statutes to the 2023 property tax assessment process, and that the relief sought was virtually identical. And she basically states here simply, the claims brought in each case arise out of the same acts, the same factual basis, and generally seek the same type of relief. And then on page 13, the judge notes that the state tax commission's argument that the two cases were different due to the fact that the first case was regarding Jackson County officials' failure to perform their duty in 2023 property tax reassessment, and the second case was about the Jackson County government's failing to comply with the state tax commission order, failed for several reasons. And we're going to get into that. Or, she said it virtually failed. And I want to show you this sentence so that there's no confusion here as to what the judge is saying in this order, really quickly. So here, right here, the court finds this argument fell. So she's specifically referring to the state tax commission's order or argument that case number 2 is different from case number 1. Okay. And again, she goes into the Missouri Supreme Court's priorly held rulings that separate legal theories are not to be considered legal claims when they arise out of the same act, contract, or transaction. So in this hearing, she's basically stating that the relief that they're asking for arises out of the same act, contract, or transaction, even if the way that they get to the relief is through a different legal theory than they would have in case number 1. And therefore, their argument fails. So then the state tax commission then argued that they would not have been able to file a request for a mandamus or a command. So mandamus means you're compelling or commanding the Jackson County government to do what you want it to do. So they're saying that they could not have filed a request for mandamus or a command for the Jackson County government to comply with this order in the first case. However, the court also found this argument unpersuasive. The court found that since the state tax commission had control over their methods to seek relief, that the state tax commission could have filed its order, then try to go to the courts for relief, but it didn't. And the state tax commission made the choice to seek relief through the courts in the first case. So they can't come back and say that, hey, we couldn't seek relief through case number 1, and so we're relitigating this case under the same under this similar case under a different legal theory to get relief through a different way. That's what the judge is essentially saying. So I actually want to showcase something here that the judge states right here, and I'm going to highlight this, but I'm also going to read it verbatim because I think it's very important. So the judge states in her order, during the pendency of the case and after the third day of trial, the commission then entered its order, which paralleled the relief it sought in the case. Immediately upon entering the order, the commission then moved to dismiss the case, which was subsequently dismissed with prejudice. The question is therefore not whether res judicata in Rule 67.01 applies to the order, which was entered prior to the dismissal with prejudice, but rather the enforcement of the order. So here, the judge is basically stating that this order is specifically going to go into whether or not the state tax commission can use the courts to enforce the order. It is not as to whether or not res judicata applies to the order. Like, so the order of whether or not the state tax commissioner's order was valid, but whether or not the state tax commission can use the courts to apply the, or to use the courts to enforce the order in the Jackson County government. This is probably the most important paragraph in the entire order. So now I'm going to read to you this case that they cite, which is the Basala case, because I think that this case provides a clear example as to why the court essentially made their decision that they made, that the state tax commissioners or state tax commission's August 6, 2024 order cannot be enforced by the courts due to the theory of res judicata. So just follow me while I read this out loud. In State ex rel Shea versus Basala, the Court of Appeals applied the doctrine of res judicata in an action for a writ of prohibition in circuit court seeking to prohibit the Civil Service Commission of St. Louis to proceed with an appeal from the employee of the city who had been laid off from his civil employment. The employee brought an action pursuant to and this is the discrimination statute in federal court against the city and the Community Development Agency. During the pendency of the federal case, the employee also brought an appeal to the CSC. The appeal was suspended during the pendency of the federal case. The federal court ultimately ruled in favor of defendants. The employee, so right here in this case, the plaintiff lost their case in federal court, okay? Now let me continue. The employee, so that's the plaintiff, then sought to proceed with his claims in front of the CSC, which the CSC is an agency, okay? The Court of Appeals found that the federal action and the appeal cause for were identical, while one case was predicated on the alleged violations under the discrimination statute and the other was based upon the city charter. The court found that it did not alter the fact that his claim and transaction from which it arose were identical. Significantly, the Court of Appeals also found that the employee, when he was laid off, was aware of the two separate avenues for which to bring his claim. He chose, or his choice, to proceed with the federal case, and he chose to proceed with the federal case and pursued it to its ultimate conclusion. Having opted to take his adversaries down one path, he may now not disregard the consequences of his own choice and compel them to follow him down another. When a party pursues one theory to judgment, res judicata extinguishes all rights of the plaintiff to remedies against the defendant with respect to all or any part of the transaction or series of connected transactions out of which the action arose. So, in layman's terms, the Basala case was about a St. Louis employee who brought a case against the city of St. Louis for discrimination. But during the case, the employee also brought an appeal through an administrative agency based upon the same facts and was seeking the same type of relief as he was in the federal court. The federal case was ruled against the plaintiff and in the city's favor. Then the employee tried to press his claims through the administrative agency. However, in that case, the court ruled that his claims in the appeal through the administrative agency avenue was barred due to res judicata because the claims and the relief sought was virtually identical. Which this case, I think, does parallel what's going on here. And so that's why I'm like, this is going to be really hard for the State Tax Commission to overturn in the Court of Appeals. So in here, the court states that they found the rationale in Basala persuasive and found that the State Tax Commission had different means to assert its supervisory authority to enforce its law and its order. But the State Tax Commission chose to bring its claims and seek relief through the courts. And because of this, res judicata will apply in this case. Well, they're saying because of this, the second element is met, but that's essentially what they're saying is it's going to apply in this case. So then they go to the third element, which is concerns the identities of the parties to the action, and they basically state the parties to the action compared to case number 1 was virtually identical. So this element is met, and then they go into the quality of the persons for or against who the claim is made. So that's element number 4. And they basically state that when defendants were identical and sued in the same capacity in both suits, is when element 4 is met. And they found that element 4 in this case is met. So therefore, the 4 elements to satisfy res judicata and bar this the State Tax Commission from issuing its August 6, 2024 order was valid. So the court is going to bar that. The court essentially is going to bar the State Tax Commission from enforcing the August 6, 2024 order through the courts. So then we get to the judgment, and this is the judgment. And just so there's no confusion, here's a judgment for case number 2. And if we go to case number 3, here's a judgment on case number 3. It's the same judge. It's Honorable Jacqueline Cook. Okay? So this is the same judge that ruled on both these cases. So the judgment is essentially that the judge dismissed case number 2, which was the State Tax Commissioner's case against the Jackson County government to enforce their August 6, 2024 order against the Jackson County government. They dismissed that case with prejudice and basically stated that the State Tax Commission cannot use the courts to enforce its order due to res judicata. They made this determination because the court stated that this matter was previously litigated in the first case, but dismissed with prejudice, and therefore the State Tax Commission is barred from asking the court to enforce their August 6, 2024 order. So, going back to the PowerPoint, we then go to case number 3, which is the March 31st, 2025 judgment, which, just as a recap for case number 3, this was a case that was filed by the Jackson County government against the State Tax Commission, and it was filed on September 4th, 2024. And the purpose of this case was that the Jackson County government wanted the courts to deem the August 6, 2024 order, the State Tax Commission's August 6, 2024 order invalid. However, in this case, the court found against the Jackson County government and found that the August 6, 2024 order was indeed a valid order. But sadly, because of the judgment in case number 2, no relief is going to be given to the Jackson County property owners because any relief from this case was barred by the judge's finding in case number 2. Now, I entitled this slide as the greatest April Fool's joke in history, or in county history, because this was an immense April Fool's joke. Because when this order was released, many newspaper sources took it to state, hey, this means that our property tax are going to be rolled back. This means that the judge is ordering the Jackson County government to comply with the state tax commission's order. But it's not, because of case number 2. And so that's why I entitled this slide as the greatest April Fool's joke in county history, because due to misinformation, a lot of people in our county have been fooled to believe that this order that happened on March 31st, 2025 would roll back our property tax assessments, but it will not. So here are some things that I took of note for implications of the ruling for case number 3. I said here April 1st, 2025, but it's March 31st, 2025. That the same judge made the ruling in case 3 that the state tax commission order was a valid order. However, the same judge, which is Judge Cook, also ruled that the state tax commission's August 6, 2024 order was unenforceable by the court due to res judicata. This simply means that the state tax commission's August 6, 2024 order is a valid order, but unenforceable through the courts. So the next slide is what can we do next? My response here is I don't know, and I'm going to explain to you, in my opinion, why I really don't know what's next, because this res judicata issue is a very serious issue. So currently speaking, case number 2 is being appealed to the Western District of Missouri, and we should know whether or not the Western District of Missouri upholds Judge Cook's order either in late summer or in early fall. In my determination, and these are my determinations based on the fact that I have done appeals and they still haven't fully briefed this case. And so with the timeline, I suspect it's going to go into oral argument in summer, and the order from the Western District Court of Appeals is going to be issued either in late summer or early fall. So if the Western District Court of Appeals overturns Judge Cook's order, yes, that means that the Jackson County government will have to be forced to comply with the state tax commissioner's order. However, if they uphold the order, basically stating that, yeah, res judicata applies because the state tax commission had the opportunity to seek the same type of relief in case 1, and since they dismissed the case with prejudice, they're barred from seeking that relief. That means that the state tax commission cannot use the courts to enforce their order. But let's go into more detail as to what that means, which the second question you have to ask yourself is, can the legislature do anything? And my response to that is, I don't know. I mean, theoretically, they could pass an ordinance ordering the Jackson County executive and assessor to comply with the August 6, 2024 order. However, I don't know if that order will hold up in court due to res judicata, because they might basically sue the Jackson County Counselor's Office might sue the Jackson County Legislature and basically state that this ordinance is invalid due to the fact that the relief that's sought in the order, which the relief sought in the order is to comply with the August 6, 2024 state tax commissioner's state tax commission order is barred due to res judicata. And honestly, the courts might make that finding that the legislature cannot make an ordinance forcing the Jackson County government to comply with the August 6, 2024 order, because the courts are barred from forcing the Jackson County government to enforce the State Tax Commission's August 6, 2024 order. But more importantly, in order for the Jackson County legislature to file such, to even argue against that case, right? They have to be represented by the Jackson County councilor. But since they don't have any representation, the Jackson County councilor is not going to they're not going to receive any representation. So let's go into another scenario, right? The Jackson County legislature, they essentially passed the ordinance to compel the Jackson County executive and the Jackson County and the Jackson County assessor to comply with the August 6, 2024 order. The Jackson County executive and the assessor might just do this, right? Like, not comply with the ordinance at all. Because then what can the Jackson County legislature do? They can't file a lawsuit against the Jackson County against the Jackson County executive to compel the Jackson County executive to enforce that ordinance, because the county counselor's office most likely will not file that case. According to our charter, the only entity that can represent the Jackson County legislature is the county counselor's office. And so it's up for the county counselor to decide whether or not to provide legal representation to the Jackson County legislature to argue the enforceability of the ordinance. And the Jackson County counselor's office might say, hey, we also agree that the August 6, 2024 order is unenforceable, or the courts can't enforce the August 6, 2024 State Tax Commission order due to res judicata. So we're not even going to file this lawsuit on your behalf. And therefore, the lawsuit won't be filed. So we have that issue too. So that's why I'm saying I don't know. But this is the end of my presentation. I'm going to take some questions that I received in the chat. So Lisa states, I am curious about something. When the county filed their suit, why did several people receive a copy of the lawsuit and or information listed in a huge spreadsheet? Lisa, I have no idea. I saw those pictures circulating around media of those huge packets the Jackson County government was sending out. And so maybe they're just sending them out to provide notice to people, but they didn't have to. But like I said before, I am not a municipal, I'm not an attorney that specializes in municipal or laws pursuant to municipalities. So there might be another reason, but I really don't know. And Lisa then states, I find it very interesting that many of us received an email from the BOE on March 31st inquiring what steps the property owners wish to take. One, continue to waive it, and I don't remember what the third one was, but then the next day we get this information. I plan to continue with the BOE, and if they don't crawl back to 15%, I will continue with the State Tax Commission. And to that, Lisa, I have to say 100%. Like, you can eat, like I would say, take your appeal up to the BOE. Like, don't even, I know that there's a way to bypass the BOE, but I would just say, just for the safety of, to make your claim as solid as possible, do the BOE hearing. Whatever the BOE says, if it doesn't cap it at 15%, then appeal it to the State Tax Commission, because the State Tax Commission has already been compelled to not increase a property tax, a real property's assessed value that was assessed by over 15% in the 2023 Jackson County property assessment. So 100% appeal it to the state tax commission, because they will. I mean, I shouldn't say they will, but they're most likely to uphold the state tax commission order, and that's the only place you can do to uphold the state tax commission order. So Tracy says, so Sean Smith and the other four that is filing the suit can. Sorry, I'm laughing because I was going to do a whole thing about this lawsuit, but because of this other lawsuit, that's why I wasn't able to do it. Let's get into this. So, for people who don't know, about a month ago, it was and please correct me if I'm wrong, because this is coming from my memory now, but Sean Smith, Manny Abarca, Deron McGee, and Vanessa Husky filed in their individual capacity a lawsuit against Frank White and potentially others in their individual capacity, basically asking him to compel him to so there was this budget issue. So let me go back, because this has to do with the budget. So the budget that was passed by the legislature on it was either December 30th or December 31st, 2024, was vetoed by County Executive Frank White in its entirety. And so this lawsuit that was filed in their individual capacity by Sean Smith, Manny Abarca, Deron McGee, and Vanessa Husky basically is stating that the county executive's veto was improper and was asking the courts to essentially force the county executive to enforce the budget that the Jackson County legislature passed on December 31st, 2024. Okay. The reason why this case is going to fail, okay, and I don't even have to put a disclaimer on this, it's going to fail, and any attorney worth their salt knows that this is going to fail, is because, and this goes back into legal theory too, is in order to man, I'm sorry, I have to go back to my legal theory. There is a legal theory. Oh my gosh. Oh, sorry. I have to look this up, because it's on the tip of my tongue. But essentially, in order to have a cause of you have to have a cause of action against a person in order to have a valid legal case. But if you file a case against the wrong parties, then you do not have a legal cause of action against them on their case. Since Deron McGee, Sean Smith, Vanessa Husky, and Manny Abarca filed in their individual capacity against Frank White in his individual capacity, this case is going to be dismissed because they're the wrong parties in the case. They should have filed the case as in their capacity as the county legislators and not as their individual capacity, because as private citizens they do not have this claim against Frank White in his personal capacity. And if you need more explanation about that, please let me know. But the case is going to be dismissed with prejudice. I looked up the current status of the case, and it's still in like a serving phase. But believe me, this case it's dead. It's an improperly filed case, and I'm actually surprised that it's being currently litigated right now. Lisa states, I don't even care about getting my money back. It's gone. I just want the 15% cap. With that, go to the STC. The STC is the best way for you to get that result, Lisa. And I wish you the best of luck with that. And I really honestly mean that from the bottom of my heart, because, you know, I've been stating from day one that this property tax assessment was unlawful. And so I hope that you can at least get some justice, because there's going to be hundreds of thousands of Jackson County property owners that are unable to receive that type of justice. And it's due to the fact that the State Tax Commission dismissed the case in case number 1 with prejudice, which is going to be one, in my opinion, one of the greatest legal crimes in Jackson County history. And I shouldn't say legal crimes, but civil, civil injustices, right? So let me correct that. So Dana says, what I don't understand is if Missouri law says increases cannot increase more than 15%, why is this even an issue? The issue is, Dana, and I'm going to try to explain this as clearly as possible, is, so let me give you an example, okay? So say, and I'm gonna give a very violent example just to push through this point, okay? Say I go up to a person, I punch them in the face, okay? Say I punch a person named Peter in the face, okay? And Peter sues me for assault. Basically, I mean, sorry, not assault, but battery, stating that I physically caused damage to his face due to my contact with his body, okay? We go to trial on this. There's video footage of me punching Peter in the face, okay? It's 100% clear that I punched Peter in the face. This case is won. Allegedly, we're still in the middle of jury trial. But say for some reason, Peter, in the middle of jury trial, decides to dismiss his case, right? The judge will dismiss the case with prejudice because it's in the middle of jury trial, but because that the case was dismissed with prejudice, even though I did punch Peter in the face, even though he did receive damages, say he was missing a tooth afterwards, like he has dental damages now, this case, I could be sued for a lot of money. Peter would be unable to refile that case against me because of res judicata, meaning that he could have sought relief through the courts. He had the opportunity to seek relief through the courts, but while he was seeking relief through the courts, he decided that he did not want to seek relief through the courts, and therefore the courts are not going to relitigate the same issue. That is what the courts decided on in this case. And Lisa also states, I also know that no one came and did the inspection for 2025 either. Yes, Lisa, please, I'm begging you, please appeal to the State Tax Commission, because that's going to be your best form of relief. So Tracy states, so if it's dismissed with prejudice, then they can't come back as a legislature to file again because they would need the county lawyers to represent them, and he can't represent both. So I'm gonna clarify this a little bit. So the Jackson County legislature, right, might have a cause of action against the county, because when we're looking at, and I'm going to go back through this, the 4 identities of a res judicata, right? When we're talking about the identity of the quality of the person for or against whom the claim is made, right? The Jackson County legislature theoretically can say, and this is all based on speculation, they can theoretically say that the 4th prong of the identity of the quality the person of the person made for, or of the person for or against whom the claim is made, does not apply to them because the legislature never filed a lawsuit against the Jackson County government, right? So theoretically, they could try to overcome res judicata due to that. But because the Jackson County legislature can only be represented by the county counselor's office, because of the county counselor's position, allegedly, this case is not going to be made, in my opinion. The county counselor is not going to file this case, in my opinion. So Lisa says, I think she's asking if MO law is 15% without inspection, how can they go above 15%? Look, the court in case number 3, okay, already made a finding that the 2023 property tax assessment, that there was significant, or there was what is it called, like there was enough evidence to determine that the 2023 property tax assessment was done improperly, and and their assessment process violated Missouri law. However, so stating that, like, they cannot go above 15% without a proper inspection or following the proper procedures. But because of the fact that the state tax commission dismissed case number 1 with prejudice, the state tax commission cannot ask for the courts to force the Jackson County government to roll back the 2023 property tax assessment value, because they could have had the same type of relief in the first case, but they decided to dismiss that case with prejudice. So that's where we are today. And yeah, which is very unfortunate because, you know, if you've been following me, I've been covering the property tax crisis for years now. And even during the trial of case number 1, I went to all 3 days of trial and tried to inform our public as to what was going on during that trial. And as I stated in prior Let's Talk Jackson podcasts, it is my honest belief, and I say this as an attorney, that we would have won case number 1. We would have won. But in my opinion, the reason why case number 1 was dismissed, and it was dismissed with prejudice, because the case happened during trial. And when trial is going on and another side wants to dismiss the case, it's always dismissed with prejudice. That's just how it is. I believe it's because Andrew Bailey didn't want to take that 30-minute deposition, and so Andrew Bailey kind of screwed the rest of us. Oh my gosh, Denise has a very long comment. I'm gonna read the comment, Denise, but I can't show it on my screen because it's too long, so bear with me. So Denise states, my mom's property was increased from 2021 to 2023 by 36.5%. She's a widow on a fixed income in a home that needs major updates. It's insane that she might have to sell her home or be taxed out of it. My best friend has been in her townhouse for over 30 years. Her value went up 75% from 2021 to 2023. She appealed and got a teeny tiny reduction, but still an increase of 64%. Her home needs major updating inside and out. It's completely unfair that they're both being taxed in excess of what either of their homes are worth. Both of these still have old photos in the parcel viewer, and I feel like the county did not do their due diligence in almost all of the 2023 reassessment, and it's completely frustrating. And Denise, I have to say, like, I feel for you. I've been very vocal about how the Jackson County government handles their property tax assessments. In fact, before the 2023 values were issued, I made an essay about how we are essentially going to go into a property tax crisis, because the Jackson County government had this essentially plan that they were going to increase everyone's values, allegedly, by approximately, I believe it's either 30% or 60%, like an average of 30 to like 30% average. But when we average that across 300,000 properties, that means that a lot of people are going to have those 70, 100, 200, 300, 500, 1,000% increases. And due to what I experienced and many people in my neighborhood, so I live in Hyde Park neighborhood, which is in Midtown Kansas City, what we experienced in 2019 was we saw that Gail did not care if she violated the state statutes, in our opinion. She would still hold steadfast that her valuation was correct, and anybody who complains just don't want to pay more because they just don't want to pay more taxes, which we were telling Gail, like, that's not true. We just want to make sure that you are doing these property tax valuations properly. But you know, that's what happened. That's what compelled me to run for Jackson County Executive in 2022 because, and I say this with utmost sincerity, I was going to do everything in my power to prevent another property tax crisis from occurring in 2023. But I lost that race. The voters decided that they wanted to have Frank White as their county executive again, and therefore we are in this situation again. And so, Denise, like, I feel for you. A lot of people in my neighborhood were also hit again in 2023, and I know that there's thousands of people whose properties right now are incorrectly assessed and that they're going to experience great hardship. But as everything stands right now, it's not looking good because the courts have ruled that the state tax commission could have uh, we could have gotten what we wanted in case number one, but because the state tax commission decided to dismiss their case with prejudice in case number one, the state tax commission cannot seek the same level of relief that they did that they sought in case number two that they sought in case number one, which means that the state tax commission cannot ask the courts to force Jackson County to roll back their 2023 property tax assessment. So I'm sorry about what you're going through and what your friends and family members are going through, but that's just what the situation is. And I just want to say, like, I'm here to provide my community with notice of what is going on, not notice of what is beneficial, but what I believe is going on, so I can give you guys the information and you can decide how to apply it. But I don't want people to think, oh, we are 100% guaranteed to getting our taxes rolled back, when that is not what the court stated. And some people are still carrying that narrative, and that is 100% the wrong narrative. And as I shown in the court's order, the real narrative is yes, the court determined that the August 6th, 2024 state tax commission order was a valid order, but they also made the determination that that order is unenforceable through the courts, and that's the only avenue the state tax commission can use to enforce their order. So Denise asks, so what's the best case scenario we can even hope for given the issue where Andrew Bailey screwed us? Honestly, Denise, the best case scenario is that right now the case number two is in the Court of Appeals. The best case scenario is the Western District rolls back the judge's finding in case number two and states that the state tax commission is not barred due to res judicata in case number two. Because if that happens, then it will go back to Judge Cook, and Judge Cook could then issue her order ordering the property taxes to be rolled back to a 15% cap. But as I shown in Judge Cook's analysis and based upon my determinations of the law, that's going to be a hard argument because the points that case number two is barred due to res judicata, there's just too many facts that support that case number two is the same case or nearly the same case as case number one. And so that's going to be very hard for the state tax commission to overcome in their appeal court. And also, just to let you know, when it comes to getting a decision reversed in the Court of Appeals, I mean, I only know the percentage when it comes to like the federal Court of Appeals and not necessarily the Western District Court of Missouri Court of Appeals, but it's low. It's like they have a 2 to 7% chance, maybe at most a 17% chance. So 2 to 17%. I say a 2% chance because when I appealed a case to the 10th Circuit, that's federal court. The court clerk told me that only 2.3% of cases are actually, or case decisions are actually reversed in that court, but that's a different court from the Western District. But with that said, you have a less than 20% chance that the Western District Court of Missouri or Western District Court of Appeals is going to overrule and reverse Judge Cook's order. And even if that happens, it's going to be appealed to the Supreme Court. And so the Supreme Court is going to have the final say. So when we're looking at late summer, early fall or fall to see what the Western District Court or Court of Appeals, what their ruling is on this case, just to let everyone know that's not the end of the story, because it's definitely going to be determined by the Supreme Court of Missouri. And so we'll then have to wait as to what the Supreme Court of Missouri says. So anyways, if that's the end of my presentation. If anybody has any questions, please let me know your questions now and I'll get to it. But if you don't have any more questions, then I'm just going to conclude this week's Let's Talk Jackson. So Dana asked, why do we have laws if the county and courts can just ignore them? Dana, what you are basically stating is, how can I say this as an attorney? So as an attorney, I've litigated, I've been an attorney for over 10 years now. I've easily litigated over 100 cases. I don't want to say over 1,000, but easily, I've litigated hundreds of cases in my career. And I'll tell you this. This is what you learn as an attorney, is that the courts can guarantee you justice, but not fairness, okay? The courts can guarantee you an avenue to receive your remedy or what you want, which is the justice prong. But when it comes to fairness, fairness is a completely different thing. So what I mean by that is, it's in this case, the State Tax Commission had the opportunity to get justice for the Jackson County residents through case number 1, or they could have decided not to file case number 1 and filed their order that they filed on August 6, 2024 and sought justice through that way. But because it was dismissed with prejudice, they barred themselves from the fairness prong, right? From getting any relief. And so the courts gave the State Tax Commission an avenue to receive justice. But because of the court's rules and because of the fact that the State Tax Commission dismissed their case with prejudice, we are now barred from any relief. And I mean, and the thing is, if you want to go back into fairness, in accordance with the rules, the rules of the Supreme Court of Missouri, like Judge Cook's ruling is fair because it complies with, it's basically fair because it complies with the rules in her opinion. Okay, so they're following the rules of the court, and in accordance with the rules of the court, the State Tax Commission can't relitigate the same case twice. Denise says, I'll vote for you. Change is needed so badly. Thank you so much, Denise. Thank you for your support. and I know people probably already know this. I'm going to make the official announcement soon, but I am going to run for Jackson County Executive again in 2026. So stay tuned for that announcement. So Lisa says, so if the courts can't enforce the order, why would the county appeal case 3? It doesn't make sense to me. Lisa, I don't think the county is going to appeal case 3. I initially thought that the county was going to appeal case number 3, because I and of course this is egg on my face. I took the what the media was saying as true, that the judge actually ordered the rollback of the property values to a cap of 15%. I took that as true. I didn't actually go and read through the judge's order. After I read through the judge's order, I basically realized, no, the judge is basically stating that the state tax commissioner's order is valid, but they're still stating that it's unenforceable. So essentially, the county doesn't have to appeal this decision because they're getting what they want anyways. And in fact, a lot of lawyers that I talked to question the fact as to why the Jackson County government even brought this lawsuit. And when I say this lawsuit, I mean case number 3 in the first place, because they got what they wanted in case number 2, which they got an order from the court basically stating that the state tax commission cannot use the courts to enforce their order. So the state tax commission essentially has an unenforceable order. Thank you, Tracy, for your support. Well, does anybody have any other questions or any clarification that you need? Because I know that this is a very complicated issue. So that's why I tried my best to give some sort of in-depth analysis as to why the court in case number 2 ruled that the State Tax Commission's August 6, 2024 order was unenforceable, and why whatever was ruled upon in case number 3, how it really has no bearing for us because of case number 2. But if not, I am going to conclude this Let's Talk Jackson, and I'm going to eat some dinner because I am very hungry right now. But even though I'm hungry, if you have questions, please let me know because I want to respond to your questions. So Denise says, how could Andrew Bailey, an attorney, not know how badly dismissing the case and its outcome would be? I don't think, and this is, or it's, yeah, it's outcome. I don't think that, so in my opinion, and if you want deeper analysis, look at my video about trial day 4. In my opinion, Andrew Bailey dismissed case number 1 not because of the state tax commission's order. That's just the excuse. He dismissed it because he did not want to take a deposition that was ordered in case number 1 due to his unethical ex parte communications with Jackson County legislator Sean Smith, okay? I don't think Andrew Bailey was thinking about the ramifications of dismissing the case or having the case be dismissed with prejudice. But I mean, I don't know. I'm not Andrew Bailey. I don't know his ideology, but I can tell you this much. Andrew Bailey is now having a tendency where all the cases that he's actually getting favorable results on. So for instance, the court case where he got a multi-billion-dollar judgment against China. And in this court case, how he does have judgment stating that, you're entitled to this type of relief, but he cannot actually collect on the relief. So like for instance, the Chinese one, he can't collect on the relief against the Chinese government because there's no entities in Missouri that are specifically, when I say specifically, like that the Chinese government in their own capacity owns. Because most of the businesses or farmland that's owned by businesses that have deep Chinese government ties are owned by LLCs, and that judgment doesn't apply to LLCs. Like in this case, they did their job in case number 3, where they got the court to actually state, hey, this the state tax commissioner's August 6, 2024 order is valid, and it's based on facts that were substantiated in the trial that happened in case number 3, and that trial happened in the winter time, right? But it's unenforceable because of case number 2, where the same judge said that the state tax commission cannot use the courts to enforce the order because it could have sought the same type of relief in case number 1. So yeah, oh yeah, and I got that, Denise. But is there any other types of questions? Because otherwise, I am going to head off. I am going to have a nice dinner, and I hope that everyone has a nice dinner this Sunday and they're enjoying this weather. Just as an FYI, we are under a potential freeze advisory. So if you do have plants, please make precautions to make sure that they are protected. But otherwise, I am going to head off. And anybody who's watching this podcast later in the day, if you have any questions, please leave them in the chat, and I will 100% respond to the question, because I understand that this is all very confusing, but I'm just trying here to help people get a clear understanding of what's going on. So Lisa says, if the court says the order is valid, but the courts can't enforce it, wouldn't that keep the order intact? The order is intact, Lisa, but in order to force anybody to do anything, you need the courts to enforce that order. Okay? So like, for instance, I'll give you an example. Well, let's go back to the case where I punched Peter in the face, okay? I punch Peter in the face. He sues me for battery. I lose the trial. I get a judgment of $100,000 against me, right? So there's a judgment, right? The court made an order saying, Stacy Lake, you owe Peter $100,000. Peter can't come to me and say, like with the judgment, and say, here you go, Stacy. Here's the order. Give me my money. He can't do that. What Peter will have to do is he will have to hire a garnishment attorney or a collections attorney, and he has to file an order for the court to sign, so that the court can say, Stacy, you owe this debt to Peter, and we're going to take away the money in your bank accounts. We're going to take away your property. We're going to take away all your assets and liquidate them down in order to pay back Peter this judgment that you owed him. Okay? That's why the state tax commission, they need the judge to enforce this order. They can't enforce it themselves. The only way they can enforce it is through their jurisdiction. So, like for instance, when oh my gosh, was it Lisa who currently has the state tax commission, or her case still in the BOE? I believe it's Lisa, but I'm sorry if I'm wrong with that. But like for instance, with Lisa's case still in the Board of Equalization position, after she has her Board of Equalization hearing, she then goes to the state tax commission level. And so the state tax commission has jurisdiction then over her case, and can use the state tax commission's order to say, you know what, Lisa, we agree with you. Your property is capped at that 15% order, because it's in their jurisdiction. But anything outside the state tax commission's jurisdiction, they'll need the court's order to do so. And that's why it's essentially, besides in cases like Lisa, where if you have an ongoing appeal right now, please appeal it to the STC, to the state tax commission, because the state tax commission can use the order to order the Jackson County government to specifically roll back your property taxes to be capped at 15%. But if you do not have an ongoing appeal right now, we're basically stuck. And that's just the matter of the fact. Or the fact of the matter. Sorry, that's just the fact of the matter. Anyways, if no one has any other questions, I am going to head out. I hope you guys had a great Sunday. I hope you guys had. I hope this Let's Talk Jackson was very informative, because that's all that I want. Is I just want this to be educational and to inform the public of what's going on. But with that said, thank you again for tuning in to this week's Let's Talk Jackson. If you have any other questions, please put your question down in the chat box and I will get to it later. And I hope you guys have a great rest of your Sunday. And I hope you have a great week next week. Stay tuned, you guys, because on Monday, there's going to be a lot of drama in the Jackson County Legislature. And I'll be back to break that down. So stay tuned for that. Till next time, you guys. See you.